So my name is Olivia Perry. I'm a partner here in the Los Angeles office of Dinsmore, specializing primarily in employment advice and counsel for California employers. I also have Sage here. He's an associate in our group, and he primarily handles wage, hour, and PAGA matters. And as I think most of you know, we've had some PAGA reforms within the last few months, and he will talk to you about those PAGA reforms. So what's on the agenda for today? Well, we have a lot to cover. We have about a dozen new and amended statutes that will have some pretty major, some minor, but definitely some impact for California employers. We'll talk about PAGA reform. I'm sure plenty of you are interested to hear about that. Definitely, some good things for employers, some pure options and some good things. It remains to be seen how big of an impact that'll have, but Sage will walk you through some of the PAGA reform. We'll talk about some recent mandates that went into effect actually over the last year, such as workplace violence prevention plans, some issues with the federal minimum wage, which will not be going into effect, but we'll touch on that. And we'll also talk about minimum wage adjustments for 2025. So the first statute we have is SB 1100, which talks about driver's license requirements. So starting January 1st, SB 1100 amends the FEHA to add that requiring a driver's license in a job advertisement, a job posting, an application, or other material is an unlawful employment practice unless two conditions are satisfied. The first condition is that the employer must reasonably expect driving to be one of the job functions of the position. And I want to highlight the fact that the statute doesn't say it's an essential job function or even an important job function, just that it's a job function of the position. And second, the employer must reasonably believe that satisfying the job function using some type of alternative form of transportation would not be comparable in travel time or cost to the employer. And the Act defines alternative forms of transportation to include ride-hailing services such as Uber or Lyft, taxis, carpooling, bicycling, or walking. So, if you think about it this way, employers always want their employees to be on time, right? If your shift starts at 8, you need to be here at 8. So putting that in a job ad for someone like a receptionist may not satisfy these two requirements because potentially the person who's applying for the receptionist position, maybe they have someone that they regularly carpool with to that building, or perhaps they live next door to the office building. So, they can easily satisfy their obligation to be there on time by, having some other alternative form of transportation. But perhaps you have a posting for an engineer for a property management company, and there are a dozen properties all spread throughout the Los Angeles County, and this engineer is regularly going to have to travel from one property to another, presumably with tools and ladders and things of that nature to do their job. That would certainly be the type of position that would satisfy these two requirements. So some best practices to make sure that you're complying would be to review any current job ads, posting, or other applications to ensure that this requirement is not included unless these two conditions are met. Also, while the law does not currently define what other materials mean, we recommend that employers review job descriptions, policies, or any handbook provisions that may also reference a driver's license requirement. We also recommend that all employees who are involved with who are involved with hiring are trained on this new statute. That would even include perhaps you have a receptionist who's answering the phone when applicants call to make sure that they understand that either, they should not be telling people that a driver's license is a requirement, or, they should just not address that issue. So make sure your employees are trained. Next, we have SB 399, which is the California Worker Freedom from Employer Intimidation Act. It's quite a mouthful. otherwise known as the captive audience meeting prohibition. SB 399 created this act, which went into effect January 1st. It creates presumably protections for employees who decline to attend or participate in employer-sponsored religious or political meetings and communications. Under this act, employers can't take any type of adverse action, that would include firing or disciplining employees who decline to participate or attend. If employers opt to work instead of attending any of these types of meetings, employers do have to pay for that time spent working. There are a number of exemptions, types of employers that are exempt, types of meetings that would not be included or fall under this act because, for example, it doesn't prohibit, it exempts certain religious entities, political organizations, and nonprofits where the meetings or communications would relate to their purpose or missions. So there are a number of exemptions and exceptions under this act. So if you think, there may be some possibility that a meeting you want to hold would fall under this act, I do recommend you work with your counsel. It creates a private right of action for employees to bring civil suits, and employers are subject to civil penalties of $500 per employee for each violation. When I was preparing for this, I anticipated that there would be some challenges to this statute, but coincidentally, on December 31st, the California Chamber of Commerce filed suit against the California Attorney General and others, challenging the statute, alleging that it violates the National Labor Relations Act and the First and Fourth Amendments, as well as some other challenges. It remains to be seen whether and how this is going to play out because the lawsuit is so new and whether the law will be upheld. So TBD, but in the meantime, I certainly recommend complying with this statute and working with counsel to ensure that you are complying. SB 2299 creates a whistleblower notice. So it requires, it put the onus on the labor commissioner to develop a model list of employee rights and responsibilities under existing whistleblower laws. So employers, as we know, have always been required to post various notices. Beginning January 1st, employers are required to post this specific notice. The notice has to be written in font larger than 14. It has to contain the telephone number to a whistleblower hotline. There were all these requirements for what needed to be in this notice. The labor commissioner did recently post this model notice that's located on their website. You can go to this website that I have linked here, or if you just Google, whistleblower notice, DIR, something to that effect, it'll take you to this model notice. So employers that do post this model notice will be deemed in compliance with the requirement to prominently display the list of employees' whistleblower rights and responsibilities. So rather than, recreate the wheel or try to come up with your own notice that you think maybe looks a little bit better or you think sounds a little bit better, the best practice would be to simply go to the website, print off this notice, and post it as you would be deemed in compliance with this statute. And this is what it looks like, essentially. Nothing fancy. AB 2499. This is a pretty big change, and it expands anti-retaliation protections for victims of violence. Most of this is applicable to employers with 25 or more employees. But again, it does provide some pretty significant protections. So the governor expanded the reach of California's anti-retaliation laws regarding employees who need time off for jury duty, court appearances, or who are victims of crime or abuse. As a result, if you are a company that has 25 or more employees, you will need to comply with various anti-discrimination, anti-retaliation, reasonable accommodation, and paid sick leave requirements with respect to employees who are or who have family members who are victims of a qualified act of violence. And
This is Karina.
hi, so, if you could just go ahead and mute yourself, sorry. Previously, employees were generally only entitled to leave if they themselves were victims of crime or abuse, but now it's extended if they have family members who are victims. And this statute follows the FEHA definition of family member, not the labor code definition of family member, which is much more expansive. So family member under this statute and under family member includes employee's child, parent, grandparent, grandchild, sibling, spouse, domestic partner, or designated person. And that designated person was added within the last couple of years. So this is a much broader definition. AB 2499 also further broadened the definition of a victim of a qualifying act of violence, which means any of the following: sexual assault, domestic violence, stalking, or an act, conduct, or pattern of conduct that includes an individual causing bodily injury or death, brandishing or exhibiting firearms, or an individual who uses or makes reasonably perceived actual threats or perceived threats of violence or use of force against another to cause physical injury or death. Under this new statute or expanded statute, employees may use vacation time, PTO, or paid sick leave if they have it available concurrently with their time off due to a qualifying reason. However, employers are allowed to limit the amount of time depending on circumstances, and this leave will run concurrently with FMLA or SIFR leave to the extent that an employee is eligible for that type of leave. Employers can limit the amount of leave for a victim who, if you have an employee who's a victim of a qualifying act of violence, they may take no more than 12 weeks of unpaid time, or rather, an employer may limit that leave to 12 weeks of unpaid. If an employee's family member is the one who's a victim, the employee may generally limit the total leave taken to either 5 days, if it's for the specific purpose of relocation or enrolling a child in a new school, or 10 days total. Employers may still require certification as a condition for providing leave, and that would include things like a police report, a court order, or other documentation verifying the employee's or the family member status of a victim. Lots of technical things to follow in this statute. Hopefully this is not a situation a lot of employers are dealing with routinely. But certainly if this is something that comes up, I would recommend, reaching out to your legal counsel to make sure you are complying. This statute also imposes reasonable accommodations on employers. Certain reasonable accommodations that may be provided would include transfer, reassignments, modified schedules, or changed work phone numbers. And these would be accommodations to keep your employee who is a victim or their family member safe. There is an undue burden analysis, just as there is under a disability reasonable accommodation request. Again, these are very, very fact-specific situations. So every situation is going to be different, but there is an undue burden analysis, and something that's going to have to be considered is keeping your other employees safe, right? You as an employer have an obligation to keep your employees safe. So if, keeping one employee who is a victim in the workplace is going to put other employees at risk, that's an analysis that needs to be done. But again, there are reasonable accommodation and interactive process obligations under this statute when you have an employee who's a victim or they have a family member who's a victim of a qualifying act of violence. The enforcement authority is also with the CRD, and the CRD, I think by July 1st, is supposed to be coming out with a form that employers can utilize with their employees when these situations do arise. So that should, similar to the whistleblower notice, should be a model form that employers would be allowed to use and be in compliance with the statute. I am going to now hand it over to my esteemed colleague Sage, to talk to you about PAGA reform.
Thank you, Olivia. My name is Sage Shaw. I'm an associate in the LA office. Today I'm going to be presenting the new laws, the reforms that PAGA, that we've seen with PAGA recently in this last year. I'm going to start out with AB 1034, but before then, and for those who do not know what PAGA stands for the Private Attorney General's Act. It's a law that allows employees to sue their employers on behalf of the state for labor code violations via civil penalties. So here we're going to start with AB 1034. It extends the original law passed in 2016 that allows union signatory contractors to bargain for a PAGA exemption through collective bargaining agreements. So prior to AB 1034, PAGA exempted until January 1st, 2028 from its applicability an employee in the construction industry covered by a valid collective bargaining agreement in effect anytime before January 1st, 2025, if that collective bargaining agreement provides for premium wage rates and expressly waives the requirements of PAGA in clear and unambiguous terms. So what AB 1034 does is it extends the current PAGA exemption for these construction industry employees previously working under a valid collective bargaining agreement until January 1st, 2038. See, the AB 1304 was previously set to expire on January 1st, 2028. This extension ensures that qualifying construction employees remain exempt from PAGA claims if their collective bargaining agreement meets specific criteria. What that criteria is, it must clearly outline wages, working conditions, and overtime rates at least 30% above the state minimum wage. It must also prohibit all violations covered under PAGA and include a grievance and binding arbitration procedure to address labor disputes. So to highlight, this safe harbor law has just been critical support for union signatory contractors. Unfortunately, this exemption does not apply to other industries. It just applies to the construction industry who are covered by a valid collective bargaining agreement. So to highlight it, we do recommend employers in the construction industry review and update their collective bargaining agreements to ensure compliance with these requirements. Right. Now we're going to move on to the PAGA reform that applies to all employers. In 2023, PAGA notices reached an all-time high of almost 8,000 filings in 1 year. In 2024, the repeal of PAGA was on the ballot. Instead of taking the risk to completely do away with PAGA, Governor Newsom struck a deal to reform PAGA. The recent PAGA reforms signed by Governor Newsom in July 2024, they have the potential to reduce PAGA abuses. Why do I say potential? Well, today we're going to discuss which parts of PAGA have been reformed, the benefits, risks to employers, and the potential new pitfalls an employer can encounter under this reform. So the PAGA reform took effect on June 19, 2024. For PAGA notices filed on or after June 19th, any current or former employee who has experienced any of the violations of labor laws may file a PAGA suit. For PAGA notices filed before June 19th, 2024, a PAGA lawsuit may be filed by a current or former employee who has experienced at least one of the alleged violations of labor laws. And we're going to go into that, what's called the standing requirement. And so part of that is going to be what's AB 2288, which introduces the major reforms to PAGA, including adjusting civil penalty structure and offering new defenses for employers facing these PAGA claims. AB 2288 requires employees to prove standing by demonstrating that they personally suffered from the alleged labor code violations before filing a PAGA claim. What this does is this helps reduce the scope of potential lawsuits. So you're probably asking, what does this mean? It means an employee or former employee can no longer sue under PAGA for meal period violations if they never suffered a meal period violation. In my opinion, this ends one of the cruelest aspects of PAGA. Prior to this reform, an employee can sue for labor code violations without personally have suffered that violation, because they were bringing the suit on behalf of the LWDA and on behalf of other employees as well. Another benefit is the reduction in penalties. There's multiple reductions in penalties we're going to go over. One of them is the initial violation clarification. Where a penalty was not provided for under PAGA, the default penalty was $100 for an initial violation and $200 for a subsequent violation. Prior to the reform, plaintiffs would argue that subsequent meant any violation after the first violation. For example, if an employee suffered multiple meal period violations, plaintiffs would argue any violation after that first was a subsequent violation that qualified for a $200 penalty. Employers, we argued that a subsequent violation could only occur after an initial violation was found to have occurred by a court or a labor commissioner. Here, the PAGA reform clarifies that the default $100 penalty applies to violations unless a court or the labor commissioner finds that the employee's practice or policy violated the law within the last 5 years, or a court determines that the employer acted maliciously, fraudulently, or oppressively. The new law does not define what constitutes maliciously, fraudulently, or oppressively, but if either of what we just discussed apply, the default penalty will increase to $200 for subsequent violations. Another reduction in penalties is the no stacking for certain violations. The PAGA reform permits the courts to reduce stacked penalties for violations arising from the same payroll policy error, such as for failure to timely pay wages upon separation, failure to timely pay wages during employment, and derivative wage statement violations. An example, say an employer unknowingly did not pay an employee who recently resigned all of their meal periods, and as a result, their wage statements were inaccurate, and they failed to pay all of the employees' wages following their resignation. As a result, that is multiple violations for the same payroll or policy error. PAGA reform now provides the courts the discretion to reduce the stacking of these penalties. In addition, we have a good faith elimination of PAGA penalties. The PAGA reform cements that a good faith dispute eliminates PAGA penalties for failure to pay all wages due and owing upon separation, for a failure to timely pay wages, and for wage statement violations that were not willful or intentional. So what does this do? This gives employers a viable argument that a court would not impose or would significantly reduce PAGA penalties for these claims. Wage statement penalties have their own category of reduction for the penalties, which is beneficial to employers. There's 3 different ways that there's going to be a new cap on wage statement penalties. The first one is going to be if the employee could promptly and easily determine accurate information from the wage statement alone, the penalty is capped at $25. So wage statements have their own category of penalties rather than moving on to the default PAGA penalties of $100 and $200. So if the employee could promptly and easily determine that accurate information from the wage statement, the penalty is going to be capped at $25. That's the first case. The second case is if only the violation is failing to accurately list the employer's name and address, and the employee would not be confused or misled about who their employer was, the penalty is capped at $25 as well. In the third case, if a wage statement resulted from an isolated or non-reoccurring event that lasted the lesser of 30 consecutive days or 4 consecutive pay periods, the penalty will be capped at $50. Another benefit of the reduction of penalties is for employers who pay weekly without being subjected to double PAGA penalties. PAGA is based on per pay period, right? On a pay period. So previously, employers who paid weekly had twice as many pay periods solely because they paid employees twice as often. To the many employers switched to bi-weekly pay periods to avoid the threat of double PAGA penalties, but some industries do require employers to pay their employees weekly. Now with the PAGA reform, employers can now pay weekly without the fear of double PAGA penalties because the PAGA reform reduces penalties by 50% for employees paying weekly. Another benefit is going to be that the fact that it's another of reform. I'm sorry, in the PAGA is that the LWDA is going to now receive less money for any settlement or verdict that is obtained in PAGA. Prior to the reform, the LWDA was receiving 75%, and then the 25% would go to the group of allegedly aggrieved employees. Now with the PAGA reform, they've reduced where the LWDA is going to receive 65% and the group of allegedly aggrieved employees is going to receive 35%. Another new component of PAGA that was part of the reform is that PAGA plaintiffs can now seek injunctive relief for the first time. All right, and so now let's talk a little bit more about a benefit that for employers with the PAGA reform on the next slide, which is going to be what's called manageability. And the PAGA reform here responds to a California Supreme Court holding, which held that trial courts do not have the inherent authority to strike or dismiss with prejudice a PAGA claim on manageability grounds, unlike where courts had that ability for class actions. The reform responds to this holding by now authorizing courts with the ability to manage PAGA claims. What that means is the courts now have discretion to limit evidence presented at trial, limit the scope of any claim filed to ensure that the claim can effectively be tried. The court has discretion to consolidate or coordinate actions alleging legally and factually overlapping violations against the same employer. Another component of the PAGA reform is a new enhancement of penalties for repeat offenders. Repeat offenders are if within the preceding 5 years an agency or court has issued a finding or determination that an employer's policy or practice is unlawful, and the employer is found to have violated that same labor code provision a second time, then that $200 violation rate would apply to that employer per employee per pay period. And that applies to, for example, even if it's not a PAGA notice, if an employer receives a LWDA claim and by just a single employee, and they make a determination that the employer has a policy or practice that is unlawful, and then later within 5 years that employer receives a PAGA notice that's alleging the same unlawful practice and policy, then that $200 violation rate per employee per pay period would apply to that. There's an argument that it would apply to that employer. So it's very important that we, if you are receiving any type of labor code claim or PAGA notice, that it is immediately addressed in order to avoid any type of enhanced penalties in the future. And now we're going to look at one of the biggest components of the reform is these broadened cure procedures. It's here and now, employers who take all reasonable steps to comply with the labor law, with the labor code requirements may receive reduced penalties. An employer who takes reasonable steps to comply within 60 days after receiving a PAGA notice of or violation can take advantage of a 30% cap on penalties. So, what are all reasonable steps? The amendments define reasonable steps to include periodic payroll audits with corrective actions, compliant written wage hour policies, wage and hour training for supervisors, and disciplining supervisors who violate the California Labor Code. The employer's conduct, whether the employer's conduct was reasonable, is going to be evaluated by a totality of circumstances. It's possible to take all reasonable steps, yet still have evidence of a violation. Say you did the audits with the corrective actions and the trainings, but there's still evidence of violations. Well, what does the reform tell us to do in that situation? Employers that cure alleged violations but do not take all reasonable steps to comply with the law will nonetheless have penalties capped at $15 per pay period. So it's important to note that the all reasonable steps cap does not apply when a court finds the employer acted maliciously, fraudulently, or oppressively, or the employer's policy practice was found to be unlawful by a court or labor commissioner within the last 5 years. If violations are isolated, non-reoccurring, or corrected within 60 days of receiving a PAGA notice, penalties may cap at 15%. There are two cases where an employee can cap PAGA penalties by showing they have taken all reasonable steps to comply with the law. So if an employer, before receiving a PAGA notice, if the employer can show they took all reasonable steps to comply with the law before they received the notice, then the PAGA penalties can be capped at 15%. In the second case, if an employer can show they took all reasonable steps to comply with the law within 60 days after receiving a PAGA notice, then PAGA penalties can be capped at 30%. I know you may be thinking to yourself, say, what does these all mean? Essentially, what the PAGA reform does, it provides courts with a greater discretion to approve settlements and adjust these penalties to ensure more fair outcomes for both sides. Now, let's talk more about SB 92. SB 92 introduces a comprehensive reform to the PAGA, establishing new processes that allow employers to resolve potential violations and reduce legal exposure. These changes include creating early evaluation conferences, expanding cure provisions, and providing new procedural rights for employers facing PAGA claims. Employers facing PAGA lawsuits now have an expanded compliance options through early evaluation conferences and cure procedures. For those who don't know what a cure, what it means to cure, to lawfully cure an violation and avoid PAGA penalties, employers must both cure by correcting the underlying conduct giving rise to the alleged violation described in the PAGA notice and must make the employees whole. The violations that an employer can cure are expanded in the PAGA reform, but there is a high bar for what's required to make employees whole. To make employees whole, an employer must pay employees in full an amount sufficient to recover any unpaid wages due to due for the prior 3 years. It may and must also pay 7% interest, pay any liquidated damages as required by statute, and pay reasonable attorney's fees and costs, which would be determined by a court or the LWDA, only if an attorney is involved. If there's a dispute over how much wages are owed, the employer can pay sums sufficient to cover any unpaid wages that the a court could determine could reasonably be owed to the aggrieved employee based on the violations alleged in the notice. And so, we're going now, we can look at the new, what the PAGA reform provides for different cure plans to employers based on their size. So small employers, which are, per the PAGA reform, fewer than 100 employees, can submit a cure plan within 33 days of receiving a PAGA notice, avoiding penalties if the Labor and Workforce Development Agency approves the correction. So beginning October 1st, 2024, within 33 days of receipt of the PAGA notice, employers with fewer 100 employees may submit a confidential proposal to the LWDA describing their plan to cure the violations alleged in the notice. The LWDA may set a conference with the parties to evaluate the sufficiency of the proposed cure. At the conference, the LWDA may determine whether the proposed cure is sufficient. It would identify any additional information necessary and then set a deadline for the employer to complete the cure. If the LWDA determines the cure is not sufficient or does not act on the employer's cure proposal, then the PAGA plaintiff can sue in court after 65 calendar days following the PAGA notice. If the employer timely cures by the deadline, the employer must provide a sworn notice to the employee and the LWDA that the cure is completed, and also must provide a payroll audit and check register if the alleged violations involved in the payment obligation, along with other necessary information to verify the cure. If the LWDA determines that the alleged violations were cured, it will notify the employer and the PAGA plaintiff. If the employee challenges the determination, the LWDA will set a hearing within 30 days. If the LWDA finds the violations were properly cured, the employee may not sue in court. Still, however, the PAGA plaintiff can appeal to the Superior Court to challenge the LWDA's determination. And now we can move on to what's for large employers, which is with at least 100 employees. The early evaluation conference options that are available for large employers are also available for small employers. And so small and large employers may request an early evaluation conference where essentially a neutral evaluator assesses claims, proposed remedies, and corrective actions, potentially allowing for court-approved settlements and reduced litigation. So employers with 100 or more employees who are sued under PAGA may file that early evaluation conference and request a stay of court proceedings prior to or simultaneous with the employer's responsive pleading or initial appearance in the action. The purpose of the early evaluation conference includes determining whether violations occurred and if they've been cured, the strength and weaknesses of the claims, whether the claims or any part of them can be settled, and whether there's information that the parties could exchange to assist in the process. The request for the early evaluation must include a statement, and it's going to specify the alleged violations it proposes to cure and other identification of the allegations it disputes. In issuing this stay, the PAGA reform requires a court to order a mandatory conference be scheduled within 70 days of the order and require appearance by the parties. The employer is to submit in confidentiality to the neutral evaluator, which can be a judge or commissioner. and serve it on the plaintiff within 21 days after issuance of the court's order. The employer's proposed cure plan to cure those violations and provide the basis and evidence for disputing any uncured violations as well. So the court's going to order plaintiff, then the court's going to order plaintiff within 21 days to submit to the neutral evaluator and serve on the employer as well a confidential statement that includes the factual basis for the violations, the amount of penalties claimed, the amount of attorney's fees and costs incurred to date, any demand for settlement, and the basis for accepting or not accepting the employer's proposed plan for curing any of the alleged violations. If the neutral evaluator accepts the employer's cure plan, then the employer must provide evidence within 10 calendar days demonstrating that the cure has been accomplished. If the employer fails to do so, the early evaluation conference and stay could be terminated by the court. If the neutral evaluator and parties agree that the employer has cured the violations it said it would, the parties may submit a joint statement to the court. If no non-cured violations remained, the court should accept the submission as a proposed settlement. If there are alleged violations that remain that were not cured, the court will have discretion to defer consideration of the parties' joint statement until after further litigation proceedings. And then if the neutral evaluator or plaintiff do not agree that the employer cured the alleged violations that is stated it would, the employer may file a motion to request the court to approve the cure and submit evidence showing correction of the alleged violations. The court may then request further briefing and evidentiary submissions from the parties in response to the motion. And so these broadened cure procedures, they don't necessarily do away with litigation, but they do create obstacles for plaintiffs if employers do decide to move forward with either an early evaluation conference or whether they do intend to make the reasonable steps to cure once they receive that PAGA notice before litigation proceeds. The wage statements do have their own specific cure provisions that if, say, for example, if the alleged violation, if the employer is curing a wage statement, then employers should follow a different procedure than those other cure procedures. It must cure the wage statement violations, and it must give written notice by certified mail to the PAGA plaintiff or their counsel, and file the writing online to the LWDA that describes the actions taken to cure within 33 calendar days of the PAGA notice. If the wage statement violations are not cured within 33 days, then the PAGA plaintiff may sue in court. So some of the key takeaways I think that we should take notice of is the PAGA reform acts somewhat as a shield and a blade for employers. On one hand, the PAGA reform generally seeks to reward employers who promptly fix their wage and hour practices and correct some of the most archaic aspects of PAGA. On the other hand, the practical implication of the reform and the unintended effects may impede progress long term. So some of the good things is that, it acknowledged that there were some PAGA abuses that have gone on, over these last few years, and at first glance, the plaintiff's bar will have to reevaluate how and why they pursue PAGA claims. Employers who immediately take all reasonable steps to come into compliance will be rewarded by triggering the new caps on PAGA penalties. If employer receives a PAGA notice and timely correction and close compliance with the new cure procedures will pay significant dividends in the end due to those caps. What's potentially bad with these PAGA reforms is that it It took away the chance to entirely get rid of a bad law with PAGA. The rules are, ambiguous and not very well drafted. It does provide plaintiffs bar, arguments to challenge these cure processes implemented, by employers. And so what that means is that employers will have to fight after investing a lot of time and money in retroactive compliance measures that may be deemed later to be insufficient. So while the cure provisions are nice in theory, they do provide some widespread fixes. They require, widespread fixes in a timeline that may not be feasible. In addition, although the evidence of these corrective actions, whether it's in the early evaluation conference or prior to and pre-litigation, they're technically settlement communications that are confidential. They can also provide a roadmap of violations and potentially certifiable issues that plaintiffs can use against employers later on. Because they would essentially give the plaintiff the information they need, say, for example, to certify a class against them in the process, which is why it's very important to have arbitration agreements with valid class action waivers for your California employees. So what does this all mean? It's, this new PAGA reform is a brand new landscape, and, employers should immediately consult with their counsel following receipt of a PAGA notice. Here at Dinsmore, our team is available to assist California employers of all sizes with audits, compliance, and defenses of the PAGA claims, with respect to what stage in the litigation or pre-litigation the PAGA claim is in. Thank you, and so thank you, Olivia.
All right, everybody. Well, that's a lot of material to cover with respect to PAGA. I have some additional information to cover with respect to some amended and new statutes. So we'll get through that in the next 12 minutes that we have. So we have AB 2123. So effective January 1st, we've always had these PFL, these paid family leave benefits program, which provides wage replacement benefits from the state for employers who need to take time off to care for ill family members or for baby bonding within a year. And it used to be the case that employers could require employees to take up to 2 weeks of PTO or vacation. Employers are no longer allowed to require that. And this simply means that these state wage replacement benefits through the PFL program are now immediately available to employees. So best practice, update any forms that you have, any written policies that you may have in your handbook or separate standalone policies to reflect this new change. We also have AB 2319, which expands the provisions of the California Dignity in Pregnancy and Childbirth Act. This is applicable to hospitals. Hospitals are required to provide implicit bias training to employees who interact with pregnant patients. This includes, anywhere from physicians to PAs to medical assistants, nurses, or any other staff members who are involved or coordinate access to medical treatment for patients. There are some pretty stiff fines for failure to comply, anywhere from $5,000 from the first violation to $15,000 for subsequent violations. Hospitals are required to annually submit proof of compliance to the AG to show that training has been completed. There does have to be refresher training, subsequent training every 2 years thereafter. So if you are a hospital or a facility that is subject to this act, just make sure you are doing this training. The first training has to be completed by June 1st of this year, and then again, subsequently every 2 years for new employees within 6 months of hire. So just make sure you're getting on to that training by June 1st. And, again, we are available if you need to develop that training. SB 988 rather is the Freelance Worker Protection Act. This is really an attempt by the legislature to provide at least some protections to freelance workers, because I think we all know California is a very employee-friendly state, right? Employees have tons of protections here in this state. Freelance workers, independent contractors have fewer protections. So this is just an attempt by the legislature to provide at least some protections. A freelance worker is pretty it's limited in the definition. It's defined as an individual or a single person organization hired as a genuine independent contractor to provide professional services for $250 or more. So if you're hiring a single individual to come in and do some cleaning services, if you're hiring a single, graphic designer, whether they have a trade name or they're incorporated, if it's a single person organization, they would fall under freelance worker definition, and it has to be for $250 or more. So we're not talking about a house cleaner that you have come in every couple of weeks for $100 to clean your house, right? We're talking about bigger projects. And essentially there has to be a written contract and payment has to be issued by the date in the written contract. And if there's no date specified in the written contract, payment has to be issued within 30 days of completion of work. There's also a pretty lengthy record keeping requirement under this new statute. The hiring entity has to retain that contract for at least 4 years. And a private right of action is also created by this act. Claims can be brought by the freelance worker themselves or a public prosecutor. I have a feeling we're not going to be seeing a ton of prosecutors handling these types of claims, just given, probably their workload and their need to focus on maybe other higher priority crimes, but it does create that ability. So please do keep that in mind. The biggest thing is they have to be written contracts. The bill also prohibits discrimination or retaliation against a freelance worker for asserting their rights under the act. And the act does authorize damages for up to twice the amount of unpaid compensation for failure to pay in a timely manner. So this is a pretty, it's seemingly a pretty easy act to comply with. You want to make sure it's written. You want to make sure you're not asking for more services after completion of the contract, or you're not failing to pay on time. We have AB 3234. This is a pretty lengthy one, and it's frankly probably not applicable to most people who are online today. So I'm really not going to go into a lot of detail given that we're pretty pressed for time. This statute has no new requirements for employers, okay? There are no new requirements under this act, unless an employer chooses to do a social compliance audit, which is defined as a voluntary non-governmental assessment of an employer's operations or practices to evaluate whether the operations or practices are in compliance with labor laws, including wage and hour, health and safety regulations, including child labor laws. I suspect most attendees on this webinar today and many of our clients are not doing these voluntary social compliance audits, and therefore AB 3234 is not applicable. However, if a company does do a social compliance audit, then there are all these requirements for what needs to be posted on the company's website with respect to what this audit found. The problem is this statute is very vague and there is very little guidance with respect to disclosure duties. For example, there's no guidance with respect to when the report has to be posted after the audit is completed. There's no guidance with respect to how long this report has to be posted. There's a lot of ambiguity. And so complying with this new statute is going to be very difficult unless or until the Labor Commissioner releases guidance or FAQs, which they may. So again, AB 3234 doesn't even define employer. It's probably a fair assumption that it follows the definition under the labor code, but again, it's ambiguous. So if there's no requirement, to do a social compliance audit, and this would really only cover voluntary social compliance audits, the recommendation would probably be not to do those, because then you don't have to follow this new statute, which again is very, very ambiguous, and compliance will be a challenge. But I just wanted to, make sure that was on everybody's radar. Then we have AB 1815, which amends the Crown Act, which amended the FEHA in 2020. It also amends the Unruh Civil Rights Act. And really all this statute does is modernizes the definition of race by removing the word historically. So the definition of race under FEHA and under the Unruh Civil Rights Act is inclusive of traits associated with race, including but not limited to hair texture and protective hairstyles. That's now the definition. And it defines protective hairstyles as hairstyles such as braids, locks, and twists. So it's, a pretty small change here, but I, again, just wanted to make sure that that was on everyone's radar. We have SB 1137, which prohibits intersectional discrimination, which means the combination of two or more protected traits. This theory of intersectional discrimination, we probably all heard about it. This has been recognized in California and by the Ninth Circuit for many years, I think since the 90s. It's just now codified under statute. The EEOC has also recognized this theory for many years. So it really shouldn't change how employers do business or change policies. What it's going to do is just now codified, again, via statute, but it helps plaintiffs, when maybe there's not enough evidence to support a claim that they as a woman was treated differently, but now they can point to, well, they as an older woman is treated differently, and perhaps point to evidence that would support their claim under both age and gender or sex. So again, it just codifies this theory that has been recognized for many, many years. And it's also applicable to FEHA, the Civil Rights Act, and the Education Code. SB 1340, this now authorizes, effective January 1st, local jurisdictions to enforce anti-discrimination laws, as long as their anti-discrimination laws are as protective as what the state has. So this was really an attempt to ease the burden of the Civil Rights Department, which is super backlogged. I mean, I don't know what your experience is, but we oftentimes see complaints come in that have to do with things that occurred years ago, and they're just now getting around to it. So this is an attempt to try to take some of the work off the CRD's desk and put it into local agencies, such as the San Francisco Human Rights Commission or the San Diego Human Relations Commission. It remains to be seen how many of these local agencies will take up these complaints and start to investigate. And if we're going to start seeing a ton of local agency complaints come across our desk, certainly we hope that's not the case, and it doesn't create a bigger burden for employers. It's too early to say, since the statute just went into effect last week. So we will just have to wait and see, but it does now provide some authority to local jurisdictions and local agencies to enforce anti-discrimination statutes and investigate claims of discrimination. Again, I know it's 1 o'clock, so I want to just quickly touch on some recent mandates. Over the summer of 2024, we did have a new requirement that almost all employers, with some limited exceptions, do have to have in place workplace violence prevention plans. If that is not something you've already done, feel free to reach out to your counsel. We can help with that. Cal OSHA has a pretty good template on their website that can be used as a really good starting point to put those together. Most healthcare facilities have had to comply with this for years, but now it's been broadened to most California employers. And there are a number of requirements under this statute Employees have to be consulted in putting together the plan. Employees have to be trained on the plan. So there are a number of things to comply with under the Workplace Violence Prevention Plan requirement. So if that's not something you've done, I encourage you to start the new year off by putting that plan together. The federal overtime rule, it was supposed to go into effect earlier this year, and then there was going to be another increase January 1st. That was thrown out. If you could just
No.
Hi, someone seems to be unmuted. If you could just mute yourself. The federal overtime rule was not in effect, so I'm not really going to cover that. The Pregnant Workers Fairness Act has been in effect since 2023, but the implementing rules went into effect last year. I don't know that this has a ton of impact in California because we have some pretty robust protections for pregnant employees or employees who are affected by pregnancy here in California already, but it is a federal requirement, so it is an additional protection for employees who are affected by pregnancy. Non-compete agreements, I think we probably all are aware that there was an attempt by the FTC to essentially ban all non-compete agreements. That was appealed. The district court issued an order stopping the FTC from enforcing that. They have appealed. We'll see what happens with that. And it's just important to note that in California, non-competes and many non-solicitation provisions have been banned for years, and they continue to be banned. And the trend on a state-by-state basis or state-by-state level is really the trend is moving away from non-competes. More and more states are banning them or severely restricting them. So if you do utilize non-competes or non-solicitations with your California employees, I strongly recommend you have those reviewed by legal counsel because they are most likely unenforceable. And there are also some requirements for California employers to notify employees of the non-enforceability of those provisions. So please do reach out to your counsel if you utilize those in California and certainly in any other state too. Just want to touch on the minimum wage adjustments effective January 1st. The state minimum wage did increase to $16.50 an hour, and that does also slightly increase the exempt salary threshold. So your exempt employees need to be earning at least $68,640 per year. So make sure you're taking a look at the salaries for your exempt employees and you're complying with that minimum wage adjustment. We also have, the minimum wage adjustment for fast food workers, which have been in effect since April. Minimum wage increase for healthcare workers, that was delayed a number of times. For me, the biggest takeaway is how broad it is in terms of how many types of employees are covered by that healthcare worker minimum wage. It's not just who we think of as healthcare workers, nurses, doctors, PAs, therapists. We're talking about receptionists, we're talking about landscapers, we're talking about janitors, we're talking about cafeteria workers who work in healthcare facilities. There have been numerous delays and the minimum wage differs on the type of facility. So please do reach out to your counsel to make sure you're complying with the minimum wage adjustments for healthcare workers. We also have about 40 individual cities and counties within California that have their own higher minimum wages. West Hollywood stands out to me as $19.65 an hour. I think that's the highest in the state. So if you do have employees, particularly if you have employees who work remotely from home or work on a hybrid schedule and some of their work is performed at home and they're in one of these jurisdictions with a higher minimum wage, you want to make sure you're keeping an eye out and you are paying them at that appropriate minimum wage. This does not impact the salary exemption. So even if you have an exempt employee who, for example, is working from their home in West Hollywood, or they're working at a work site in West Hollywood, the state minimum wage is the one that you look at, the $68,640 per year. So I know there's always a little bit of confusion in terms of the exempt threshold. The higher local minimum wage does not impact that threshold. So I know we've ran a few minutes over, and my apologies for that. I don't know if we had any questions, but I think the best thing, since we have run a bit over, if you do have any questions, would be feel free to reach out to Sage or I. I do understand that a copy of this PowerPoint is going to be going out to everyone who's attended. So you have the information, you have our contact information, so please feel free to reach out.